Welcome back to another episode of The Lawyer You Know, and today we're going to break down Lori Vallow's defense team's actions and comment on what they're doing, if it's what they're supposed to be doing, if it's what we would do, if it's what a normal criminal defense attorney would do in this case. We're going to hash that out because you, the listeners and viewers, want to hear our opinions on that. So that's what we're going to do in today's episode. We also got some comments on John Pryor, who is Chad Daybell's lawyer. And people were asking similar questions. So if you guys want me to do a deep dive on John Pryor, look into his website, look into his credentials, see what kind of a lawyer he is and what kind of a lawyer he sets himself out to be, let us know below by posting your favorite emoji in the comments below. And whatever emoji you post, I will assume it means you want us to break down John Pryor, his actions in the case representing Chad Daybell, and do a deep dive into his website, into his credentials, which we will do if you want to hear about it and if you want to watch it, because that's the point of this channel. So if you like this type of content, please subscribe, like this video, and let us know what you want to hear, because we enjoy doing these breakdowns. We enjoy unpacking the facts. We enjoy bringing you knowledge and information that you're interested in. So today we're going to break down what are Lori Vallow's lawyers, or the lawyer in particular, Mark Means, what is he doing in her defense? Is it unusual? Is it abnormal? Or is it the normal course of business for a criminal defense lawyer? So to get these questions answered, I've brought on Big George, our in-house criminal defense expert. He's been doing it forever. He's been on both sides of the aisle. So he's going to tell us and break down some of the things Mark Means has done and whether or not it's appropriate, after watching the video I did a week or two ago breaking down the fact that Mark Means doesn't seem to have a lot of criminal defense experience. So to start out, what is your overall thought, before we get into specifics, about a lawyer like Mark Means, who seems like a family law lawyer or maybe a civil litigator, taking on a criminal case like this?
Well, if you can believe what we know, which is he's never had a felony case. He does not really put himself out much as a criminal lawyer. If you look at his website and you see how he's advertising and the kind of cases he's pushing for. Frankly, in seeing how he does his work and how he's filing the motions, I can see where he doesn't really have a lot of experience. So that's the part that bothers me early on in the case, and you commented on this in your last video. Any lawyer, no matter what kind of law he practices, is allowed to go into the courtroom and represent somebody on almost any matter. And so he legally can go in and represent her on this case. Whether he's doing a good job or not is something that the future will tell. But he can be there. Now, what he has done so far, he has basically kind of read the book of what kind of motions you should file, and he has filed the motions a normal lawyer would have filed.
Like what? What are some of the motions that are normal in every criminal case that he's filing in this case?
Well, he filed a motion to reduce the bond. That's in the very beginning.
So that happens in almost every case where there is a bond when the criminal defendant is arrested and not just left out or let out ROR.
Right, and the bond is this high. I mean, this is obviously an astronomical bond and justified. I'm not saying it's not. But it's such a high bond, you would always try to reduce that bond.
And so how did that go? What did you look into his motion for a reduced bond? How did it go?
All right. Well, it originally started out at $5 million. And remember, initially, he represented Lori as well as another lawyer represented Lori. And they together argued on the $5 million. Then the other lawyer left, and then he came in to reduce the $1 million because it was reduced from 5 to 1, and there was no reduction. Which again, not unusual, the right thing to do, file the motion, the judge rules, that's it.
And did he make all the normal arguments, like she's not a risk to society, she's not a flight risk, she's not rich enough to where she can disappear, anything like that? Even though, now what goes against her is the fact that they fled to Hawaii after the kids were allegedly murdered. So some of that's working against him. No matter how good of a lawyer you are, you can only reduce the bond so much.
It was no surprise it didn't get
But
reduced.
He did get a reduction from $5 million to $1 million, and he did what he was supposed to do to try to reduce that bond. So far, so good. What else has he done?
All right, another thing that he's done that's right is he's filed a motion for change of venue, which means trying to get that case out of where it's located in that town, put it somewhere else. Frankly, I don't know where somewhere else would be that would have less publicity, because I'm sure the entire state of Idaho, I mean, it's not that big, doesn't have that many people. Nobody in Idaho doesn't know about the Lori Vallow case.
We talked about this in the Ronnie O'Neill trial. We talked about it in the Derek Chauvin trial, right? You try to move this venue if you feel like the venue you're at is not fair. He did that. It makes sense. frankly, of those 3 cases, this seems the least likely to move, and the other 2, those motions were denied and they did not get to change the venue.
And here's where we get into doing what like the book tells you to do, file the motion for change of venue, and doing it the right way. He filed the motion for change of venue very bare bones, and he said more to come in the motion, because you've got to prove, the burden is on you to prove that there won't be a fair trial in that jurisdiction. He didn't add the newspaper accounts, press accounts. He didn't hire someone to go out and do a survey of the population to say 70% of the people couldn't be fair, so you can't get a fair jury. He didn't do any of the normal stuff that we do when we try to get a change of venue. He just asked for it, because again, the book tells you to ask for it,
and
but you've got to back it up.
Probably the first one he's ever done. I mean, we don't know that to be a fact, but that's probably the first criminal change of venue case he's ever done. So it's hard to know everything that you're supposed to do to try to stack that motion with proof as to why you need a different venue. It doesn't necessarily write itself like the Derek Chauvin and George Floyd one, which again was still denied. So it may not matter. The motion still may have been denied even if he did it right, but he didn't necessarily put all of the evidence and backing to that motion that a more seasoned criminal defense lawyer would do.
Right.
All right, what else do we have?
All right, then we have the motion to compel, where he asked for the discovery from the state, and the state hasn't given him everything or didn't do it on a timely basis. I think they were 8 days late, which is late, and the judge recognized it was late. So they filed that motion. They won that motion, and the state was ordered within 14 days to give them all of the things they're required to give them under the rules. So they're holding the state's feet to the fire. And in conjunction with that, they also filed a motion to disqualify the prosecutor. And now we get into...
Well, hold on. Before we get to the disqualification,
sure.
The motion to compel discovery, that's very similar in civil actions, right? In family law court, criminal, civil, we all have discovery. There's deadlines. If the other lawyers miss the deadlines, you file a motion to compel, you explain why they're late, you show the rules. So we expect him to be able to do that, right?
Yes.
Because he has been a lawyer for some time. He went to real law school, like I said. He is a real practicing lawyer, seems like a family law lawyer, but even a family law or civil lawyer will be able to handle the discovery process easily without much problem.
All right. And
so he did that fine, but now one of the big objections we've seen in the comments, and a lot of people said, oh, it was so horrible of him to try to disqualify this prosecutor. He looked like an idiot trying to do it. What do you think about that? Generally speaking, let's talk about trying to disqualify a prosecutor or a judge. Have you ever done it in a criminal case? Have you been successful? And what is the reason for doing it before we get to actually specifically what happened in this case?
Okay. Yes, I have moved to disqualify judges, sometimes successfully, sometimes unsuccessfully.
What about prosecutors?
Normally you get a first shot. Normally you can disqualify the first judge you have. The problem you have is you don't know what you're going to get. So you may disqualify this one, and you may get one that's even more trouble for you, and you have a tough time disqualifying the second one, because usually it's one bite of the apple.
Right, and it's easier to disqualify a judge than it is a prosecutor. Right. So have you ever tried to disqualify a prosecutor?
I have, and that's never been successful.
Okay.
And
what are some of the reasons you would try to?
Well, one of the reasons would be is that the prosecutor themselves were going to be a witness in the trial, that they were actually going to testify. So you really can't have a prosecutor on the witness stand and have a prosecutor prosecuting the case. It kind of looks kind of weird to a jury to try to figure it out. Plus, jurors give prosecutors a lot of credence, just like they do police officers. And therefore, you don't want a prosecutor up there testifying and being a witness. And
also being in the lawyer in the case.
Right.
And so I think in some other cases, especially if you look at, I can't remember the guy's name, Manitowoc, Making a Murderer, Stephen Avery. In that documentary, the prosecutor at the end ended up getting, I think he lost his license or lost his job because he was hitting on and pressuring victims and criminal defendants that he was prosecuting for sexual favors and stuff. And it was all these creepy messages. So that guy can get disqualified from a bunch of cases in the future and potentially any case that he was on currently if they find out he was doing that with other victims or other criminal defendants.
Let me tell you, the facts are unique. And let me just tell you, I know of a case where a defense lawyer was actually having sex with the wife of his client during the trial, and the appellate courts, although the bar disciplined him, the appellate courts did not reverse the case.
Defense attorney or prosecutor?
Defense attorney, and they didn't reverse the case. They didn't think that that was too outrageous, although the bar had some discipline to talk about it, and they've talked about that in this case too. The bar discipline versus the court disqualifying.
And we'll get into what the prosecutor did
right.
and why. We'll get into that in a second, but It's unusual to disqualify a prosecutor.
Very unusual. Very hard.
Because everybody expects it to be a little contentious, right? It's a big
Right.
case. It's a murder case. The prosecutor probably feels very strongly that they want to go get justice against these horrible murderers. And the defense attorney may think they're innocent and wants to fight hard against everybody, proving their innocence. So you can understand why their heads will butt. And just because you butt heads, just because you may be not cordial with each other, even though we are taught to do that in our profession of ethics, a lot of times that doesn't happen. And just because you don't like each other doesn't mean you're going to get somebody disqualified. Was this a noob move for him to try to do? Meaning he doesn't know what he's doing. He's trying to disqualify it. It was a waste of time. He should have never done it. He looked like a fool. Or was it legitimate? And why was he trying to disqualify this prosecutor?
I think that the lawyers in this case, Mark Means, is taking the posture that they're going to be very aggressive, that they are just going to go after everybody and everything. And so they're going after the prosecutor. I mean, we can talk about the grounds if you want, but I didn't think there really were good grounds for going after the prosecutor, but they went after the prosecutor. And when they talk about this prosecutor, they really go after him. When they talked about the motion to compel, where they were going to get the discovery before, we talked about that, they were going after him. I mean, he was 8 days late, and they were calling him all sorts of names.
I wish we could get that in some of our civil cases.
Yeah,
8 days
you know,
late.
I know, 8 days late, and they were jumping all over him.
And so, I don't want to keep jumping back and forth, but in discovery, a lot of times you just grant extensions. So
Right.
usually you would just grant that if you're going to be cordial, but that's not how this is working, right?
Not
and
in
that
that
is not usual. Like if you're a seasoned criminal defense lawyer, you work with these prosecutors all the time, you're going to let them have 8 days to provide the discovery.
Well,
Usually you're not going to crush them over because you may need a couple days for discovery, and you just are cordial with each other.
Right.
Now, if they do it over and over again, or they're delaying the case or not giving you something you need, fine. But if they're a week late, usually you don't blow them up in front of the court because the judge also doesn't like to see that. The judge does not want to see you fighting with the other lawyer. But let's get to the recordings, the tapes, why he wanted to disqualify this prosecutor.
Well, if you look at the recording, and you look, and I looked at a transcript or partial transcript of the recording, that prosecutor did nothing that most prosecutors don't do. He was aggressive. He was pushing that witness. He was telling that witness all sorts of things so that that witness knew he had a good case, that he was going to come down on him, and that that witness needed to cooperate and needed to talk. That's what every prosecutor does. They talk to the witnesses. If the witness is not friendly, again, this was, I believe, a relative that they talked to. That's not going to be a friendly witness. So you have to make that witness understand. You better tell the truth. You better tell it now, because telling the truth later may be too late for you.
Right, threatening them that if they obstruct justice or lie or anything, that there's going to be criminal charges against them. They could be aiding and abetting this criminal. That's always what they do. It's not unusual.
Not unusual.
So a couple comments on that. Number one, some people came in the comments and asked me questions about that recording saying, we all know it's illegal, so how is it possibly going to be used at trial? Well, is it actually illegal?
In Idaho, it is not. In Florida, it would be.
Because there's a two-party agreement that you have to know before you record somebody in Florida, but it's only one in Idaho.
One party in Idaho, which is so bizarre when you think about it.
You're allowed to record private conversations, right? Which is really unusual, but you're allowed to, so it wasn't illegal, and that's why it could potentially be evidence in the case. So when talking about that, how could it be evidence? Could this be played while that witness is on the stand by the defense attorney to say, weren't you pressured before you ever gave your testimony?
Well, when the judge denied the motion to disqualify the prosecutor, the judge put a caveat in the motion. And the caveat was, if this person did testify, then the court would look at it again. Because first of all, we don't know if this person is even going to be a witness. And at that point, they'll look at it and say, well, can you put the tape in to impeach the witness? Or is the prosecutor going to become a witness at that point? The court left that door open.
Right. And I do think a lot of times, even if they're not going to disqualify the prosecutor or strike a witness, they usually will allow the defense attorney some leeway in using that and showing the jury that the prosecutor put all this pressure on this witness before the witness gave the statement that may be damning to the defendant, right?
Yes.
Because that goes to the weight of the evidence, not the admissibility. So the jury can say, man, I don't know, maybe that prosecutor did pressure them to saying something, and we leave that kind of up to the jury sometimes in situations like this. So based on that, do you think it was enough to disqualify the prosecutor? Would you have filed a motion to disqualify the prosecutor?
I would not have, because I've been a prosecutor. I think jurors want prosecutors to be tough. And therefore, they're not going to hold it against that prosecutor that, he was tough with this witness. I don't think there was enough. He didn't really do anything improper. One thing he did do improper, and the judge did call him out on it though, during that discussion that he had with the witness, he just ripped apart the means. He ripped them apart. He's never had a felony trial, blah, 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 blah. And the judge admonished him at the hearing and said, you know what? Maybe you should think about apologizing to Mr. Means for the things that you said, because really, he should not have said that stuff. That's not part of what he should have done.
And I think, we can sit here and say we would not have filed a motion to disqualify. I think if he came at you personally, realizing if he said that about you, it wouldn't be true, so it wouldn't be as offensive. But for Means, it was probably pretty offensive since a lot of it was, I don't want to say he's a bad lawyer, but he had never had a felony. He doesn't have a lot of criminal experience. That stuff is true. So I can understand why he filed a motion to disqualify. I don't think it makes him an incompetent lawyer because he filed that motion to disqualify.
No.
Maybe we wouldn't have done it, but it's not like he's making these just like out of this world decisions as a criminal defense lawyer to this point, in my opinion, from what I've seen, what I've read, what I've heard. What else sticks out to you kind of through the process that he's done as her criminal defense lawyer?
Well, initially when they had their first appearance, he made an appearance for both Lori and
Chad Daybell.
For her husband, right? He appeared, he said, I represent both of them. Now, you can't do that, especially in Idaho. Idaho does not have the same kind of husband-wife privilege that Florida does. In Idaho, there is no privilege in confidential communications between husbands and wives if there is a crime or if it has something to do with protecting a child. And in this case, we have both. So Chad may end up becoming a witness at some point in the future, and yet for a brief moment he represented both of them. I don't think the court may do nothing about it, but the bar may have something to do about it later on.
Right, and I think if he would have handled criminal defense cases more, then he would know that.
Yes.
But what else? Anything else? He's done a lot throughout the case. We're not going to nitpick every single thing, but what else? What else do you want to talk about?
Well, another thing he did was he has filed a ex parte motion for protective order. Now, you may say, okay, what is an ex parte motion for protective order? Ex parte means no one but you and the court knows about it, which means they've cut out the prosecutor on what that motion said.
Ex parte communications are frowned upon.
Yes,
normally.
they're frowned upon, and a protective order is something that says you can't talk about this. The judge says, I order you not to talk about this. Now, I've only seen protective orders in two types of cases. One is when I represented a defendant in a national security case because the government doesn't want state secrets to be out in public, so they did a protective order that I couldn't reveal those. We did another one where we represent somebody from January 6th up in Washington.
Okay.
And we have a protective order there so that we cannot reveal the videos they've given us from the Capitol building.
Some of them.
Yeah, some of them.
Some of the evidence they've given us, we can't talk about, we can't reveal. Was the first case you're talking about the undercover agents?
The undercover
because that was another one. That case was crazy. Like you guys would be, we got to do a video on that one day. So we represented a guy that was accused of being a terrorist, and the stuff they were allowed to do in that trial, meaning everybody would leave and we would just be sitting there with our client. The FBI agents, the prosecutor, and the judge would go in some back room and come out and just tell us we can't talk about this anymore. And then we're in the middle of cross-examining a witness.
Right. And I would say, what did you talk about in that back room? I'm sorry, national security.
So that's a story for another day. But it's insane sometimes what they can do in some of these cases under the banner of national security. But okay, so those are the normal protective orders.
Right, but why in this case? I mean, how could you possibly ex parte protective order?
But what was he asking for?
We don't know.
Okay.
Because it's ex parte. It's a sealed motion. And the prosecutor's got to be jumping through hoops.
Usually it's the other way around. The prosecutor's usually the one that gets to hide stuff from us.
What can be so secret that I can't know as a prosecutor? We're trying this case. We're going to trial on a multiple murder case. What can we, what's going on here?
Right, so that doesn't make any sense.
No.
What about the treatment and the evaluations and the power he wants over that? That again, remember, he's used to family law and civil court where we as the lawyers have a lot of power over what doctors are involved, what documents come out, what can and can't happen to our client. Our client can say no to this or yes to that. What did he try to do and why is it not necessarily something criminal lawyers do?
It's the same thing. He looked at the book and yes, it's the right motion to file. You file a motion for competency, and by the way, we should explain, This is competency to help your lawyer with the trial. Has nothing to do with your guilt or innocence.
Not an insanity plea, a competency to stand trial.
And we'll talk about insanity in a minute because Idaho's a little different too. But so he says, look, my client's not competent. My client can't help me with my defense. So he files this motion, which he should do. Right thing to do. But what you can't do is you can't control the narrative after that. When the professionals take a hold of that client, you can't say, and he's requested this, I want to know their methods of treatment. I want to know if they're going to give them drugs before they interview her, before they give them drugs, because he wants to approve it all. He wants to approve all the conversations. You can't do that. They're mental health experts, and she went to a state hospital.
Well, that's
to
the
be
point.
examined.
It's not like this is a doctor chosen by the prosecutor.
Right.
And it's definitely not a doctor chosen by the defense. It is an unbiased doctor that this is what they do, basically. And they are not biased towards either side. They're going to come and give their opinion after doing an evaluation.
Yes.
That's just how it works in criminal cases. In civil cases, we provide the reports done by our client's doctor. Her or his treating physician gives us a report, we review it, and then we turn it over. That's not how it works in criminal cases.
Right.
Which he may not know that because he doesn't do. All right, so what else has Mark Means done that we want to kind of point out here?
Well, now we have kind of like the unusual part, which we really don't know what's going on, and that is he files a motion, again, certainly proper, to declare her indigent. And so she is declared indigent. Indigent means she can't afford her own lawyer or the costs of a defense. Normally, when you're indigent, a public defender gets appointed to represent you. In this case, Mr. Means is staying on the case. Now, I don't know what that means if he's staying on the case. He complained because he's not getting any money for costs.
Well, let's talk about this real quick. Let's pause this and back up a little bit. Was he court appointed or chosen by her?
Chosen by her and retained, as I understand. Of course.
But we also, there's been a lot of comments that they think he was retained for the child custody. She was kind of like her family law lawyer before any of this happened.
According to, again, in court, and I listened to part of this, in court, the lawyers said, we have been retained to represent her on the criminal case. So, and I'm talking about both lawyers when she had two lawyers.
But as we know, just because you say retained doesn't mean you were paid any money. As we know,
right.
Lawyers that have gone to the courthouse for high-profile cases and asked those defendants to hire them for free. So just because you retained doesn't mean you were paid. I'm not saying that's what happened in this case. But just because she's indigent now and has no money doesn't mean she still didn't retain him and he's taking a discount or no money because of her fame. Because now we know she's indigent, which means she doesn't have enough money to pay for this. Why would he do that? Does that help him get more money, or what does it do to declare a defendant indigent if you're retained as her lawyer?
Well, I don't know why he's staying on it other than the publicity. Because she has no money. A court has done an investigation and found that she is indigent. She doesn't have. She declared bankruptcy a couple years ago, so she doesn't have any funds.
But isn't the point of doing that? Like if you're a lawyer and you get your client declared indigent, can't you get some state funds to pay for experts and stuff like that?
Only if there's a conflict. In other words, only if you have a situation where the public defender can't represent you. Because if you're indigent, that's what a public defender is for.
So you can't get both. People. You can't pick your own lawyer and get the public defender type experts and help with court costs. You can't do both?
No, you can't do both. Either you're indigent or you're not indigent. Now, him staying on...
I guess the only way I've seen that is with court-appointed private lawyers.
Right. Who had conflicts. Where the public defender couldn't represent both.
But isn't there a
defendants.
time that sometimes you can have somebody declared indigent and ask for them to appoint you as the lawyer? Like we've done that in federal court where we represented somebody through the whole process and it's the end and now they can't pay anymore, but the court still appoints us as the court-appointed lawyer, so you still get paid by the state.
But he hasn't done that.
Okay. But you can do that, but he hasn't done that.
You can, but he hasn't done that. So you have to, I guess logic tells you, right now he's not getting paid. He really, honestly, ethically, can't really stay defending her.
Why?
Well, because we have a rule, and we have the same rule that Idaho has, and most of us have kind of massaged the ABA rules on who is qualified to represent somebody in a death penalty case.
So there's certain certifications, right?
Right.
That you have to have.
There's classes you have to take. You have to have tried so many felony trials.
But because they're not there yet,
experience.
They haven't brought the death penalty yet, have they?
Not true in Idaho. In Idaho, on a murder case, the rule says at that point they should ask for a qualified lawyer unless you have a private lawyer. A private lawyer, if you pick a private lawyer, I don't care if if he doesn't know where the courthouse is, he can represent you on a death case. But on an appointed case, that has to happen right in the beginning. There's cases in Idaho where preliminary hearings, which is the first hearing, are stopped because the public defender stands up and says, Judge, this is a murder case and he deserves someone who's death penalty qualified, and nobody in our office is, and they have to go find somebody from another office to come in.
So, but you're saying if she chooses Mark Means and he represents her as a private counsel, he can do it even though he's not death penalty certified?
That's the strange thing about this is he appointed or is he privately retained? He just said he's staying on the case. She's been declared indigent. So, I mean, is the court going to just allow him to represent her for free and not be death qualified, even though he's not getting paid as a private lawyer?
So that begs the next question. If she does all of this and chooses him and he goes forward and she loses and gets the death penalty, does that set up a claim, or how does the court or the prosecutor or anybody protect from setting up an ineffective assistance of counsel claim and appeal after she loses by hiring a lawyer that doesn't know what he's doing? Potentially. I'm not saying he doesn't. I'm not saying that's what's going to happen. But is she trying to set up a claim like that? How can the court and the prosecutor protect against that?
Well, I think we're going to have to see a hearing. And that hearing is where the judge is going to tell her, look, hey, Lori, this guy is not death penalty qualified. This could be a death case. Now, this prosecutor has yet to declare that this is going to be a death case. No doubt in my mind they're going to. How much more aggravation can you have than what this person has done, allegedly, according to the indictment? And he's going to say, do you waive your rights to have a death penalty qualified lawyer? And do you select him as a private lawyer? Because we know the rule requires if he's appointed by the court, he has to be death penalty qualified. If she selects him, then it can be waived. And the judge is going to have to make it clear. So they're going to do colloquies
and make sure it's knowing. But here's the problem, though. If she is not competent to make these decisions, how long is he going to be able to stay on knowing he's not qualified, knowing he's not court appointed or state appointed? At least we don't think he is. He's not death penalty certified, so if he was state appointed, he wouldn't be qualified to stay on the case. At what point does the state take over her decision-making ability?
Well, and also the question is, if she's incompetent, was she competent to hire him in the first place at the very beginning of this?
And how does that change when her competency changes?
Right, if her competency goes in and out, and there's been clients like that where it goes in and out, and a guardian has to be appointed. They've got to appoint a guardian. The judge is going to have to take a hold of this at some point and just not let it run wild like it is. And frankly, this prosecutor looks pretty aggressive as well. I've seen him in press conferences, and he's pretty aggressive at the press conference. He's got to get a hold of this too, because he's got to worry, I don't want to convict somebody that's going to get reversed on appeal, and I've got to come back and try him a second time.
Everybody sees this coming from a mile away.
Yes.
I mean, there are plenty of cases where we have no clue anything about the lawyer, but they're a criminal defense lawyer. Whether they're good or not, we don't know. They go, they lose, the client gets convicted, and we move on. But in this case, from the jump, everyone in the country following this case is like, this doesn't seem right. He doesn't seem qualified for this. He seems like he's in over his head. This seems like ineffective assistance of counsel, and if we can all see it, an appellate court is probably going to agree.
Well, and there's an old saying that death is different. Death penalty cases are really scrutinized by appellate courts. They are reversed quite a bit because people don't want to make that mistake of executing somebody who really isn't guilty. And that's why this is going to be scrutinized a lot closer than any other appellate kind of case. Normally, even incompetent lawyers can get away with representation because the United States Supreme Court, in the case called Strickland, established a standard for competent representation, and it's not very high. Unfortunately, you can just be minimally
You basically
competent.
have to do something to where your client would have won the case, but for how terrible you were.
Right. Basically, you have to sleep through the whole trial.
Yeah, and even then, sometimes you're not declared incompetent or you're not declared ineffective.
So the Strickland standard is not very high. Death penalty, different. That standard is high.
So what do you think about, this is kind of the last question, unless you have anything else you want to add. What does it say about Mark Means? Is it a conflict? Should he be disqualified if he's in a relationship with Lori Vallow, which a lot of people are speculating? It's kind of gossip, but we can just talk about whether or not when attorneys and clients have relationships, or if he's in the same religion or cult that she is in.
Okay. Well, I can answer the cult because the LDS, as I think they were talking about.
Latter-day Saints.
Right, Latter-day Saints. He is definitely not one of them.
Okay.
In fact, he's attacked the church on
we've
several
seen that.
occasions.
Yeah, he actually brazenly, which that's something I noticed that I would never do in a case, is write a letter like that and accusing them of witness intimidation, because they basically said...
Criminal action.
Yeah, he basically said the church has told all of its members, and she was also not just part of the Latter-day Saints. There was also some sub-cults that she was in, so I'm not calling them a cult necessarily. But anyways, I'm just saying, like, he came after the church saying they told everybody in their church, all of their members, they can't speak to anybody without talking to church lawyers first, and that includes judges and cops and lawyers who are all members of that church, which any normal, logical person realizes that that's not how it works. Like cops and judges that are in the Church of the Latter-day Saints are not going to go talk to that's not how it works, you know. And he was trying to accuse the church because of some of the things the church has done, and the church did. Was it a press release, or there was something that the church did?
It's a letter. They have a letter they send out to the members, advising them of how to conduct themselves in court proceedings.
Right.
I think it was 38% of Idaho.
A huge percentage.
Yeah, is LDS, 38%. So it affected a lot of people, and that's what he was concerned about. But the letter was really aggressive.
He went way too far. I would never do that as a lawyer in the church. If you want to point something out or do a press release about it, fine. But those accusations, to me, maybe he's trying to create a change of venue, because the 38% of people that saw how he attacked the church are probably not going to like him. So maybe he's just trying to add to the fact that this is not a fair venue. And I do think that that is one of the issues. The fact that it's such a high percentage of the population in Idaho, that could create a biased jury pool. But wouldn't it be biased in her favor? And I don't know.
Let me talk about you just for a second on change of venue. He would not have clean hands in that motion, because I have to wonder, how did his response to LDS get out and get into the press? Did he release it? If the defense lawyer causes the publicity, he can't complain about the change of venue.
Yeah, so that's something that I had. That was one of the biggest things I had a problem with. Other things, I think a lot of lawyers would do the same thing he's done throughout the process. Yes. I think a lot of lawyers. It's not like he's made any humongous mistakes. A lot of people on YouTube think he has. We don't necessarily see it that way. It wouldn't be the way we would handle it necessarily, but I don't think he is just...
Well, I think, though, what's really happened is the real proof in the pudding comes now. What he's done so far is not the nitty-gritty of representing the client.
Right.
Now he's getting the discovery. Now he's getting the witnesses. Now he's got to prepare for trial.
Does he know what to look for? Does he know what to ask? Does he know how to poke the holes versus prove a case? That's one of the big deals.
Does he keep things close to the vest, or does he expose himself by telling the state everything he wants so the state knows what he's doing? You know, those are the things, the strategies of experience. That comes now.
Yeah. So I guess we'll keep an eye on this, and if you want us to comment more, let us know in the comments. But again, a lot of questions about John Pryor. If you want us to do a deep dive and talk about what he's done in the case, leave your favorite emoji below. Make sure you subscribe to this page and like our video. That's all we have for you this time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.